Okay, the Senate will come back to order now. We're ready to begin our debate on House Bill 757. I would just reminding all members relative to the decorum of the debate. Please be mindful of your words. The chair does have a lot of discretion over this, and I may choose to use it. Secretary will read House Bill 757.
House Bill 757 by Representatives Tanner, the Ninth, and others. A bill to be entitled an act to protect religious freedoms to amend Chapter 3 of Title 19 of the OCGA relating to marriage generally so as to provide that religious officials shall not be required to perform marriage ceremonies in violation of their legal right to free exercise of religion, to amend Chapter 1 of Title 10 of the OCGA relating to selling and other trade practices so as to change certain provisions relating to days of rest for employees of business and industry and for other purposes. Mr. President, the Senate Committee on Rules recommends that this bill do pass by substitute, respectfully submitted by Senator Mullis of the 53rd. Mr. President, the Senate Committee on Rules offers the following substitute to House Bill 757. A bill to be entitled an act to protect religious freedoms to amend Chapter 3 of Title 19 of the OCGA relating to marriage generally so as to provide that religious officials shall not be required to perform marriage ceremonies, perform rites, or administer sacraments in violation of their legal right to free exercise of religion, to amend Chapter 1 of Title 10 of the OCGA relating to selling and other trade practices so as to change certain provisions relating to days of rest for employees of business and industry, to protect property owners, which are religious organizations, against infringement of religious freedoms, to define a term, to amend Title 50 of the OCGA and for other purposes.
Mr. President, minority report has been filed and is on your desk.
Mr. President, a minority report has been filed and is on your desk. Mr. President, that completes the order.
Chair recognizes Senator from the 13th to present the bill. Please give the Senator your attention.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I present to you House Bill 757, and we just want to go through this real quick. House Bill 757 came on a vote from the House, a bipartisan vote of 161 to 0, and the first part of this I'll just kind of walk you through. On line 28, you'll see that a refusal by an ordained minister to participate in a ceremony he doesn't want to is protected. The second thing in section 2 on line 43, you see that it protects a church or a religious organization from not being in business or operating on their days of rest. And thirdly, it protects in section 3, and you can see it specifically on line 54, no religious organization shall be required to rent out their facilities for any type of ceremony or any kind of group that they don't agree with. So that, in a nutshell, is what the House bill that came to us that was voted again bipartisan, 161 to none, that we are looking at today. Now, I have added the First Amendment Defense Act to this bill. And so let's talk about that for just a minute. We've talked about it a great deal already in this body, and we have vetted this thing a lot. And I think the best approach to addressing this today is to tell you what this bill is not. In the AJC, they reported, cited that large companies that have non-discrimination policies in the state of Georgia will not be able to enforce those non-discrimination policies when an employee asserts that their sincerely held religious belief allows them to discriminate based on marriage status, based on sexual orientation, based on whether somebody is single or divorced. Ladies and gentlemen, I want to submit to you this is simply not true. I want you to understand that this bill is all about equal protection. It only, and this is key, it only impacts the government's interaction with faith-based organizations or a person who holds a sincerely held religious belief, specifically as it relates to marriage. It's very narrow, very focused. Last year we had a bill that we did pass in this chamber, It's called the Religious Liberties, and or the RFRA bill, I'm sorry. And there was a lot of complaints about that bill. Oh, it's just too broad. It's just too this. Now we come this year with this bill, and it's very narrow in scope, and now you're saying, oh, that's too narrow in scope. You know, I don't know. I'm trying to strike a balance. Let me tell you why this isn't true. Look at page 3, section 2 of the bill. We're in Title 50 of the Code, which solely pertains to state government. It has nothing to do with private enterprise. Secondly, this only impacts government interaction with a faith-based organization or a person who maintains a firmly held religious belief surrounding marriage. Third, nothing in this bill impacts a company's relationship with its employees. When a company hires an employee, that employee is given a handbook, they're given their policies and procedures, and that is what governs that relationship. This bill does not interfere with that one iota. I'm proud of the state of Georgia, and I'm proud that we are the #1 state in which to do business. I'm proud that people from all over the world call Georgia home. This bill will not change that. We as a state are full of hospitality, and we have room for all people. This legislation is about equal protection and not discrimination. Secondly, I've heard critics say that this legislation codifies discrimination against same-sex couples, the LGBT community, and cohabiting individuals, and further stigmatizes these groups. Again, this is simply not true. This bill protects the constitutional rights of individuals and faith-based organizations in Georgia. This bill takes nothing away from same-sex couples or members of the LGBT community. It simply limits the ability of government. There's that word again. Underline it. It's important. It limits the ability of government in Georgia to take an adverse action, and that is spelled out very clearly for you in this bill in lines 71 through, let's see, how far do we go with this? 71 through 88. So that tells you exactly what it says it cannot do. It limits the ability of government to take an adverse action like denial of tax status on the basis of a person or faith-based organization's views and beliefs as it relates to marriage alone. One issue. I hope you heard me. We are providing protections for all beliefs. Look at lines 100 through 105. This is very important. Again, government shall not take any adverse action against a person or faith-based organization wholly or partially on the basis that such person or faith-based organization believes, speaks, or acts in accordance with a sincerely held religious belief regarding lawful marriage between two people. That can be, including the belief that marriage should be between a man and a woman, or that sexual relations are properly reserved to such a union. In the United States of America, we recognize marriage between two people, be it same-sex couples or traditional couples. That's what we're dealing with. We're protecting legal marriages in this country and in this state. Lawful marriage between two people, that, ladies and gentlemen, is equal protection, not discrimination. Another thing I've heard about this bill, I've heard concerns that this singles out a specific viewpoint on a single issue and provides heightened protection for that viewpoint. First of all, in the recent U.S. Supreme Court decision which brought forward the single issue of marriage, as has been our goal along, HB 757 is neutral as to the views or beliefs about marriage between two people, we do not address it. We understand and recognize that the law of the land says marriage is between two people, be it a same-sex couple or a traditional couple. It is neutral. This bill is neutral as far as that is concerned. It is a live and let live bill. The bill forbids the government from taking action against a person or faith-based organization on the basis of its views on lawful marriage between two people. That's on line 104. In other words, if a person sincerely held religious beliefs lead them to believe that marriage is proper between two members of the same sex, two members of the opposite sex, both are acceptable under this bill. That's equality. This bill prevents the government from taking adverse actions against that person or faith-based organization regardless of what they believe. We are not picking sides. This bill does not favor one viewpoint over others, which is exactly how government should act in regard to religious beliefs. Another concern I've heard, the definition of faith-based organization would allow for a for-profit business to amend the governing documents in order to come under this bill's protection. Claims have been made that this bill would foreclose state and local government agencies in Georgia from taking any action against such businesses in the event they refuse to serve a person because of their sexual orientation. The bill only prevents the government from taking a very specific set of actions that are outlined in this bill against individuals and truly faith-based organizations and groups. I'll point out lines 71 through 88 again, how we define the adverse actions. That's already listed out for you there. If you read these closely, all of these are situations in which a person or organization has some type of special relationship with the state that others may not necessarily have. Government contracts, scholarships, license, tax status, etc. There are also all items, if the government takes them away, you could quickly find yourself out of business and unable to operate if the government took an adverse action against you. I don't think government should be able to take away your livelihood because of your religious belief that you hold. Let's be real clear. There is no current private company or corporation, I don't believe, that will falsify their governing documents to claim faith-based status. You know, as a businessman, I'll tell you what drives business, and that's are you going to make money and turn a profit or not? That's what's going to drive the business. We are talking about truly faith-based entities no matter what the size. We're not talking about trumped up things. We're talking about truly faith-based organizations. If a company or a church or a nonprofit based on the will of its members holds itself out to the public as a faith-based organization, I'm all for that, and I'm all for protecting them. If its members don't feel that's appropriate, that's okay too. They don't have to be. It's their decision. Again, this bill is about not forcing things on people. I think that their rights to express a viewpoint should be exactly the same, and that they should be able to do that without the threat of government and adverse action. Finally, I also received a few emails yesterday, and they were talking about some of these things. Oh, Senator, this is going to create workplace discrimination. Under your bill, all business non-discrimination policies would essentially be void, making it legal to discriminate in hiring and firing. That is not true. We have laws that protect employees, And there are certain ways employers have to go about in their human resources department in their hiring and termination of employment in this state. This bill does not change that one iota. It does not affect. It has the effect of government interfering, not that employer-employee relationship. Secondly, domestic violence centers. An unmarried single mother fleeing an abusive relationship with her child to be turned away from critically needed centers under this act. Listen, those domestic violence centers receive federal dollars. And here's what happens. If your organization receives $1 federal dollar, maybe you got a $2 million budget, but you get $1 federal dollar. Federal law trumps everything, regardless. You cannot show and say, this dollar was spent on this one, this dollar was spent on that one. So this does not fly. I have explained this on the ropes to the folks with the domestic violence centers. I thought we had it cleared up. I also had an attorney go and talk to the folks about this very thing. I thought it was cleared up, but then I heard it again in testimony, and then I get in an email yesterday. Apparently, they don't understand. But it's very clear, if you get $1 federal dollar, that trumps state law. Third, homeless shelters. FADA could serve as an excuse to deny emergency housing to an unmarried couple and their children with nowhere else to go. All of these are not true. And I don't know who's passing these untruths around, but let me tell you something. It must be someone who's never spent time in a faith-based organization that reaches out to the homeless or tries to feed the hungry. I have never known in my years, and I've been in the ministry since 1988, I have never known a faith-based organization to turn anyone away. In fact, our Bible teaches us to meet people where they are and minister to their needs. I could quote you a lot of scriptures on that. Finally, I want to say this. I noticed that the Senate Rules Committee has the minority report here. Employers could fire a single mother taking family leave from work if they believe sexual activity to be reserved to marriage. That's not true. This bill deals with equal protection, and it deals only with the impacts that government interaction has with faith-based organizations or a person who holds a sincerely held religious belief. The employer-employee relationship in a private organization is not affected by this bill. So I could go through the list. None of these hold water. And the second part that they have, discrimination based on sexual orientation, is already legal in Georgia. Well, no, it's really not it by default, because we just don't have any laws addressing that. So if you want a law to address that, work on that. But this law does not allow for discrimination. I'll just kind of close with this, or I'll take questions after this. We're going to vote today, and this is a critical vote. And I know that we have party lines drawn, and I know we have feelings about all this. But I want to tell you something. Every one of us that goes to church will be in church more than likely this Sunday. And I want you to look those church members in the eye and tell them how you voted for this bill. Because I submit to you, ladies and gentlemen, the reason we need this bill in Georgia, there are millions, listen to me, millions more Georgians who hold that marriage is to be between a man and a woman than that marriage is to be between same-sex couples. All we're doing is providing equal protection for both points of view. Mr. President, I'll yield for questions.
Chair recognizes Senator from the 39th for a question. 39th. Chair recognizes Senator from the 39th for a question.
I'll pass for right now.
Chair recognizes Senator from the 34th for a question.
Thank you, Mr. President. Would the senator yield?
Certainly.
Senator, in the sub LC 256573S, line 98, I think that says person means any natural person. Can you give me 3 examples of a natural person's?
Me, you, the senator from the 12th, and the senator from the 3rd. That's 4.
And I thought you would say that if the senator would further yield.
Certainly.
So when you start saying me and you, you're a man, I'm a woman. Besides you being a man, I'm a woman. Name a 3rd one for me, please, if you will.
A 3rd person?
Natural person.
I don't understand your question, Senator.
Okay. Thank you so much, Senator. I'll regress because thank you.
Chair recognizes the senator from the 10th for a question.
Thank you, Mr. President. Would a senator yield?
Certainly.
Senator, my concern has to do with faith-based organizations. And I see what your definition is in here for a faith-based organization, but there's an or between any organization or legal entity. I guess I'm trying to understand what is exactly, if it's not a legal entity that's a faith-based, what other kind of faith-based organization could it be?
Well, you can have S corporations, C corporations, you can have LLCs, and so forth.
I believe, Senator, those are legal entities.
Right.
You have an or between any organization, then you have the conjunctive or, meaning other legal entities. I'm just trying to understand, other than these legal entities, what exactly, what is a faith-based organization other than those legal entities that you just mentioned?
Well, we just wanted to make sure we covered them all, Senator.
Senator, further yield?
Sure.
Senator, my concern, considering the history of this state and all those hate groups that I'm sure all of us in here are aware of, would any of those groups, according to this definition, be considered faith-based if they chose to identify themselves as such?
Well, I'm 52 years old. I'm not very familiar. You talking about before my time, or what are you talking about?
Senator, we have many hate groups out there today. No, I'm not talking about before your time or before my time. I'm just talking about hate groups in general.
You know, faith-based organization means an organization or other legal entity whose governing documents or mission statement expressly acknowledges a religious belief or purpose. Do any of those fall in a religious, faith-based organization now that you're talking about? I'm not sure which groups you mean.
Senator Yale,
Certainly.
if you would allow me to ask the questions and not answer them for you.
Well, I got to have more information sometimes to kind of get to where you were going.
Not a problem. Where I'm going is there's a lot of different organizations out there in this state. Under your definition, any of those organizations, it appears from what I read here, could consider themselves a faith-based and come under this legislation. Is that correct?
They can't consider themselves. That must be in their governing documents, yes.
Senator, further yield?
Certainly.
Is it not very easy to change a governing document?
Yes, it is, but aren't those documents, if they're registered with the Secretary of State's office, don't they have somewhere to answer to?
Senator, again, you're asking me questions. I'm just trying to get the answers from you. This is your legislation. I don't know what you mean by it, so perhaps you can expand on it a little bit further.
Well, I mean, it's lines 89 through 91.
Senator, further yield?
Yes.
And if you need to consult with legal counsel for that definition, I'm okay with that. But let me just kind of tell you where and why I asked you that question. We're all familiar with the terms KKK. Is that not correct? Meaning the hate organization, Ku Klux Klan?
I've read about them, yes.
Some of my heritage have done a lot more than just read about them, and I certainly understand where you're going. But my concern is, couldn't that organization, if it chose to do so, identify itself as faith-based?
And again, I'm not an attorney. I don't know. I guess they could, Senator. I'm not sure.
Senator Further.
I don't know what would stop them.
Senator Further Yield.
Certainly.
So there's nothing in your legislation that would stop them. Is that correct?
That's right.
Does that present a problem for you, Senator?
Does it present a problem for me? No. Again, I mean, I've read about those groups, but you know, I don't know that this certainly isn't directed towards them. It's directed towards churches and towards ministers and towards organizations that provide adoptions and organizations that provide help to the homeless and so forth.
Senator Further Yield.
It's for equal protection as well. Yes, sir.
I heard you initially say the answer is being no. I would certainly hope that you would search your heart and understand how the gravity of dealing with an organization like the KKK, particularly for those of my persuasion, could create problems underneath under this particular legislation. And essentially, it would empower some of the things they would do by discriminating against certain classes of people inherent in your legislation. Aren't you providing a vehicle for them to do exactly that?
I don't think so, Senator. I really don't. And you know, I did watch the Super Bowl the other day, and I did see a tribute to the Black Panthers. I guess that'd be kind of the similar group that we're talking about, and I guess they could fall under this as well.
Senator Further Yield?
Yes.
Senator, I don't believe there's any comparison between a Black Panther group and the Ku Klux Klans. I don't know if any Black Panther group has ever hung a person of color from a tree.
I don't know that there's a comparison between the Ku Klux Klan and adoption agencies either, or homeless shelters.
Senator Further Yield?
Yes.
Senator, you've mentioned the word equal protection a number of times.
I have.
Show me in your document where it says equal protection. Is there a line?
The fact that we recognize marriage as defined by the Supreme Court, that it recognizes same-sex marriage and traditional marriage.
Senator Further Yield?
Yes.
Senator, I believe the term that you used was equal protection. I'm trying to find, and I've read your document extensively, LC 25-657-3S. Show me or identify a line in here where it says the words equal protection that you referred to several times in your arguments.
Again, we define it by the definition of, the legal definition of marriage is what we're talking about. And this is the one single issue that we're dealing with.
Senator Yield, if you can refer, and I know there's probably other questions, and I do apologize for being so lengthy with my question, but I'm trying to understand.
That's all right.
really
I ate
what
a
the
good lunch, so I'm
implications
good.
are. So
Go
did I,
ahead.
Senator, and I slept at the Holiday Inn too. Senator, show me if you can identify a line in here where that marriage language, which refers to equal protection, would be applicable. Could you do that, please, Senator?
Well, again, it's on line 100 through 105. And it's specifically on 104. And we'll back up to 103. With a sincerely held religious belief regarding lawful marriage between two people. That is what we recognize in the United States, is that marriage is between two people. It can be a same-sex couple or a traditional couple. And that's where I'm getting the equality from, that we're addressing both of them equally.
Senator Further Yield?
Yes, but
Senator, thank you. I just have to refer to line 54, where it refers to no religious organization shall be required to rent, lease, or otherwise grant permission for property. That line, as well as some of the other lines in your legislation, is that considered equal protection?
well, you could have a group that holds the same sex beliefs and has a place that they don't want to rent out to a traditional wedding, so yes.
So that's your definition of equal protection, is that correct?
I think we've covered that.
Thank you, Senator.
Thank you.
Chair recognizes Senator from the 3rd.
Senator Yield.
I will.
Senator, I'd like to go back to line 98 where we discuss person. Isn't it true that sometimes the law considers corporations to be persons?
Yes,
And so the purpose of this here is to identify a person as a human being, correct?
that's correct. Yes, that would be another definition of person is corporation.
And does the senator have one more question? Will you yield to one more question?
I will.
Isn't it true also that on lines 134 through 136 that this law is to be subject to the protections subject to the United States Constitution and the Constitution of the state of Georgia?
And that is correct, yes.
And so all of those protections that fall under those constitutions are still in place. They're not being disturbed,
No.
are they?
They are not.
And those include equal protection of the law.
Yes,
They prohibit racial discrimination.
Yes.
And all of these other things.
exactly.
And so this law is subject to those protections.
That's correct.
Thank you.
Mr. President, I yield the well.
Senator has that right. But Senator, there's Pro Tem wants to ask a question, if you'll yield.
Will the senator yield for 2 questions?
How could I not? Yes, sir.
I want to follow up the line of questioning from our good friend, the senator from the 10th District. Isn't it true that this bill provides absolutely no protection to an individual or faith-based organization that engages in a criminal act?
That's true, yes.
So regardless, so if a domestic terrorist organization like the
Yes.
Ku Klux Klan were to engage in some sort of criminal act, it wouldn't matter what's in its bylaws, this bill would provide it no protection whatsoever.
None whatsoever. That's correct.
Thank you, Senator.
Yes. Mr.
You
President,
yield, or are you yielding?
I'll yield the well.
Okay. The senator has yielded. Now, Chair recognizes Senator from the 42nd. 42nd.
Thank you, Mr. President. Colleagues, I rise in opposition to the portion of this bill that is the so-called First Amendment Defense Act. Incredibly, I actually find this amended legislation really almost worse than before because it seems to vastly broaden the categories of people that are impacted. Because the protections contained in the bill encompass any belief, speech, or acts that are in accordance with a sincerely held religious belief regarding lawful marriage between 2 people. So to me, that reads any belief about what 2 people should be allowed to get married. So notwithstanding any federal laws, by the plain language of this legislation, it would therefore protect the viewpoint that, for example, interracial couples and interfaith couples should not receive the same treatment as other couples. In fact, it would even, if you will, protect the viewpoint, if it was sincerely religiously held, that 2 short people shouldn't get married, if that's your religious belief regarding marriage between 2 people. Another glaring problem turns on the definition of lawful. I understand from the Senate, the bill sponsor, the senator from the 13's comments that lawful is meant to modify marriage, and so that would be interpreted in that way to be discussing marriage that is already legal under U.S. law. However, if it modifies back to belief, and at the very least it's inartfully drafted so that there is a question, it could be interpreted as a belief regarding what is lawful, then that would protect the viewpoint that marriage should not be limited to 2 people. There are, as you know, a number of troubling religious sects that believe in polygamy and the forced marriage of female children to male elders. It's not drafted very, very artfully, Senator. I understand that's not your intent. In fact, the so-called Fundamentalist Church of Christ of Latter-day Saints was kind enough to very recently, I don't know if any of my other colleagues received it, mail me a hardback treatise at my home. It just came a couple weeks ago. And this manifesto had a lot of revelations from Warren Jeffs, who is currently in prison for sexual assault against children that he claimed were his spiritual wives. At the very least, this is inartfully drafted, it's inarticulately drafted, and the question exists what lawful is modifying. And if it's a belief about what should be lawful, it would then cover people with a belief that marriage could be between more than 2 people. Further, FATA also includes the troubling and unprecedented language that people can be discriminated against based on their sexual habits. This sanctions discrimination against single mothers, people who have had affairs, people who cohabitate, people who are divorced, people who are remarried, and many others. Further, this newly enshrined ability to discriminate would not just be limited to people or religious nonprofits. It would cover any organization or legal entity that documents or mission statement acknowledge a religious belief or purpose. Yesterday, I did some very brief internet research and discovered that both Chick-fil-A and Hobby Lobby, for example, have religious mission statements, and I'm sure that there are many others. And as the senator from the 13th stated, it would not be difficult for a company to change their mission statement or governing documents to include a religious purpose in order to obtain the legal arguments and protections that this legislation is to provide. I'm going to walk through a number of the constitutional infirmities in this law, and please do bear with me because there are a lot of them. First of all, the bill violates the free speech clause of the U.S. Constitution because it has both content-based and viewpoint-based discrimination. Laws that target speech based on content or subject matter are subject to strict scrutiny and are presumptively unconstitutional. In Reed versus the town of Gilbert, a church successfully challenged a sign ordinance that treated political signs more favorably than the church's meeting signs. Justice Clarence Thomas, writing for the court, explained that a law that singles out a specific subject matter for differential treatment, even if it does not target viewpoints within that subject matter, and here we are singling out religious viewpoints about marriage, is a paradigmatic example of content-based discrimination. On its face, HB 757 treats speech and activities related to marriage between two people more favorably than all other speech on all other subject matters. Moving on to viewpoint discrimination. First of all, I do disagree with the senator from the 13th that the bill is actually neutral. I understand that by making the two people change, it was intended to get around viewpoint discrimination charges. However, it does still affirmatively single out the belief that marriage should be between one man and one woman for additional protection. It's the only one written in the law, so you can't really escape the charge of viewpoint discrimination. Judges would certainly view that. Some might agree that two people saves it. Many others would say you've still elevated a belief that marriage should be between one man and one woman above any other viewpoint related to marriage. So that's not neutral. The Supreme Court has held that the government must abstain from regulating speech when the specific motivating ideology or the opinion or perspective of the speaker is the rationale for the restriction. In Rosenberger versus Rector and Visitors of University of Virginia, the court explained that the state university newspaper could not select for disfavored treatment student journalistic efforts with religious editorial viewpoints. In the same way, the state may not disfavor non-religious viewpoints. Unfortunately, this legislation does just that by allowing religious viewpoints and not secular viewpoints to justify trumping existing law. This bill would also violate the Establishment Clause of the U.S. Constitution in two ways. It creates a religious exemption that causes real harm to other people, and it grants discretionary powers to religious organizations and businesses that may then place a religious litmus test on who they serve. The Supreme Court has held that, at some point, accommodation may devolve into an unlawful fostering of religion. This is important. That then violates the Establishment Clause. To avoid an Establishment Clause violation, a religious exemption must be measured, and I'm quoting, so that it does not override other significant interests, and it may not impose unjustified burdens upon others. In the case of a state of Thornton v. Calder, Inc., the Supreme Court struck down a blanket exemption for Sabbatarians because it, quote, unyieldingly weighted their religious interest over all other interests, including the interests of coworkers. This legislation grants individuals and religious organizations that hold religious beliefs about marriage a blanket exemption to all laws that conflict with their religious beliefs. It fails to take into account any potential harms such exemptions would cause to others. That clearly burdens and harms others based on this single religious viewpoints regarding marriage and are therefore impermissible results under the Establishment Clause. Further, the government under the Establishment Clause may not give religious organizations discretionary government powers. In accordance with this bill, faith-based organizations can take state, local, or federal funds to provide services to the public and then use a religious test to determine whom they will and will not serve. This is not just unfair, but unconstitutional. In the case of Larkin v. Grendel's Den, for example, the Supreme Court overturned a law that allowed churches to veto applications for liquor licenses in their neighborhoods. The court explained that the government cannot delegate or share important discretionary governmental powers with religious institutions. However, this bill would delegate or could delegate governmental authority to religious organizations in the case of if the state is giving money to nonprofits that are religious that may run adoption agencies, homeless shelters, etc. The state is then delegating some of its authority in that area and specifically allows them to use religious criteria to determine who gets and who is denied public services. Finally, the bill does violate the Equal Protection Clause of the U.S. Constitution. In Romer versus Evans, the state of Colorado passed a law that would overturn all state and local non-discrimination protections for LGBT Coloradans and prohibit state and local governments from instituting new non-discrimination protections. A look ahead. And I think the look ahead is important to discuss because that's one of the things that we need to talk about here. The justification that they gave for that law was that it would protect those, quote, who have personal or religious objections to homosexuality. The Supreme Court, however, rejected these justifications and determined that the law was unconstitutional because it was passed to make LGBT Coloradans unequal to everyone else. And again, I think it bears repeating that the only viewpoint pulled out in a clause related to marriage between two people is the viewpoint that it should be between a man and a woman, which means it's specifically pulling out one to make that group more unequal to everybody else. In Romer versus Evans, that was directly struck down. Further, this legislation could, in the same way, nullify future efforts that our state might have or local governments might have to pass future non-discrimination protections for married LGBT Georgians. I have a couple other things I want to mention really briefly, and I know everyone's brain is spinning from all the Supreme Court cases, so these are going to be really fast. So there's legislation on the First Amendment Defense Act at the federal level. Yes, our bill's now different, but that's where this originates. Hasn't even gotten a hearing. No other state has done this. There's very, very real questions about economic impact and harm. Look, I've just walked through some finer points of constitutional law. That's something that lawyers talk about. What people out in the real world understand and hear is very different. And perception is reality, many times in a business context. There are lots of people that work in our hotel industry. You'll see a lot of letters on your desks about the 4,000 jobs they are afraid we would lose. And nothing about constitutional law matters when you're talking about that, because that's right over everyone's head. I would implore this body not to pass legislation that we know suffers from numerous constitutional problems and infirmities, simply for political reasons or to pander to a particular constituency. We should be better than that, colleagues, and moreover, we have more important business to attend to. I would ask that we all vote today against HB 757. But, Mr. President, I'm happy to answer any questions.
Chair recognizes Senator from the 29th for a question.
Will the senator yield for a series of questions?
Absolutely.
You made the comment in your remarks that the bill before us would allow a faith-based organization to discriminate against an interracial married couple. Is that right?
I assume you're contending that under federal law, that would be impermissible.
Well, no, I'm just asking if I understood you correctly during your remarks, that
I
this
think that
bill would allow that.
I think that that is a very valid question to ask, whether it would do that.
Okay, and you're familiar with the Supremacy Clause of the U.S. Constitution? are you
Absolutely.
not? And there is a federal law that prohibits racial discrimination, is that correct?
There is.
And that federal law would supersede any intended or unintended effect of this bill as far as any sort of race discrimination, is that correct?
I think, Senator, when you're passing a law that's written as broadly as this is, you do need to look at the language contained within the law itself, because that's what people are going to see, and ask if you've properly contended with those questions.
Right, and so my question is, because you've made a serious charge here about the effect of this legislation, the federal law that prevents racial discrimination would prevent any race discrimination, whether this bill is made law or not. Isn't that correct?
I would say that if we had not engrossed the bill, it would have been wise of us to amend it so that that was clear.
Now, you also mentioned that there were implications regarding polygamous marriage and child marriage as well. Is that right?
I think it's inartfully drafted, and those questions are alive depending on how you read, what word you read lawful to modify, yes.
And at line 104 of the bill, line 103 and 104 of the bill, the religious belief that we're talking about is that religious belief regarding lawful marriage, correct?
Correct, and as I said, it depends on if lawful modifies belief or marriage.
Do you agree with me that both polygamous marriage and child marriage is unlawful by the laws of the state of Georgia?
I do. The question is whether or not we are talking about someone's belief about what marriage should be lawful, or whether we are talking about what marriage is currently lawful. And if it's someone's belief about what marriage should be lawful, then that would encompass persons whose belief is that marriage should not be limited to two people.
And as far as, again, the argument about polygamous marriage, following line 104 after lawful marriage, it says between two people, right? So wouldn't that exclude any polygamous union of any kind?
Again, it would not if the question is on someone's belief about lawful marriage about two people.
Now, let me ask you just if you yield for a couple
Certainly.
more. Shortly after the Supreme Court decision, a University of Georgia professor took the position that a consequence of that decision was that religious organizations that teach traditional marriage should be taxed. So I'd like to know, do you believe that houses of worship in this state that teach traditional marriage should be subject to state tax, local property tax, and other taxes?
That's not something that I have delved into. I'm not certain I know all the parameters about what you're asking me about. My concern is that, there may be a time, viewpoints change, right? Culture changes, which is one of the reasons that the discussions on this very topic are so different than they were 25 or 30 years ago. So I do have concerns that if we as society coalesced around a different viewpoint in the future, that this legislation would be able to nullify those actions.
So again, my question though is, do you believe that houses of worship which teach traditional marriage should be taxed in view of the Supreme Court decision last summer?
I really don't have any information about that topic. I'm sorry.
Okay. How about, do you believe that faith-based adoption agencies, which because of their belief on marriage and the family only adopt out to married opposite-sex couples, should be shut down by government?
No, I don't.
And do you believe that religious schools which teach traditional marriage should be stripped of their accreditation because they teach traditional marriage?
Nope.
Do you believe that religious schools ought to be free to enforce morality clauses in contracts to reinforce their teaching on marriage and the family?
Not really.
Okay. Thank you. I have no further questions.
Thank you.
Chair recognizes Senator from the 54th for a question.
Thank you, Mr. President. Will my friend and seatmate yield?
Yes, I will.
Senator, I'm trying not to be duplicative. The Judiciary Chair took some of the things I wanted to ask you about. I do want to follow up on, in particular, you listed sort of this parade of constitutional infirmities, and I want to start with the cases you cited first, the Reed versus Town of Gilbert and the Rosenberger cases. Both of those, you would agree, are traditional First Amendment cases. Isn't that true?
Let me find them. Yes.
Well, isn't it true that Reed dealt with the sign ordinance and
Yes, it
Rosenberger
did.
dealt with
Yes.
newspapers?
Yes.
And you would agree that nothing in House Bill 757 deals with the media in any way? In other words, this is not a restraint on any sort of publication in any way, shape, or form?
You know, I'm not totally sure that couldn't come into play.
Could you direct me to the provisions that would deal with a restraint on media and publication?
Well, I agree with you on traditional media. But as far as signs or putting things of that nature up, that's where I think maybe that's the caveat that I was trying to put out.
Fair enough.
Yeah.
On your Establishment Clause cases, I think the one you cited was the state of Thornton. And
Yes.
my question to you, or a couple of questions on that if I could you tell us what you believe the unjustified burdens of this legislation would be under the balancing test for an Establishment Clause case?
Sure. And again, this is, as we discussed, legislation there are a lot of different weighty constitutional questions that come up as we discuss this. No doubt there will be court cases that have to analyze this, but let me point out before I mention a few examples that, as I was always told by my political advisors during my campaigns, if you're explaining, you're losing. And that's really the problem with this legislation, that perception does become reality, and if you're explaining, you're losing on the national stage. But here are scenarios that, at the very least, we would have to explain. And again, reiterate, if you're explaining, you're losing. I have a few. Where are they? I have them, sorry. Here we go. Taxpayer-funded homeless shelter could refuse a single mother and her child a bed. Hospital could deny a man the right to speak to his dying spouse for the last time. Or a city-funded domestic violence shelter could refuse to offer a woman safety because she is sleeping with a man who's not her husband. Those results would murder and harm others.
Could you identify in the definition of adverse action which paragraph those actions would fall under?
Well, so say those actions were taken, and they were by, say, a homeless shelter or a nonprofit that we state fund.
Yes.
So, say that we, as the General Assembly, disagreed with those actions, then our hands would be tied in whether or not we could withdraw that money or take any other actions against that nonprofit.
Can you help me out there?
Yeah, I mean, it says deny, withhold, or reduce, or exclude, or terminate any public benefit to the faith-based organization.
On the exclusive basis, and I direct you to the operative language, on the exclusive basis that organization espoused any particular view on marriage.
Right, if their view was that, it encompasses sexual activity, right? So if their view is that people who are unmarried, it says that, so.
Senator, what I'm trying to get at is the fulfillment of a contract. The fulfillment of a contract.
Okay, I understand what you're saying.
The fulfillment of a contract.
We'd have to look at every single contract.
If you have a contract that you don't fulfill, it's terminated based on lack of fulfillment, not based on your views, not based on your ministry, not based on your religious point of view. It's based on your lack of fulfillment of the obligations you undertook in the grant. If we don't write good grants as a state, is that not our fault as opposed to Georgians' fault?
It certainly is. Again, if you're explaining, you're losing, and I guess we'll go back and review every single contract to make sure that actually the provisions that this bill clearly opens the doors for would actually not be acceptable. We'll I suppose, go back and make that clear in all those contracts.
Senator, will you continue to yield for a couple more questions?
Certainly.
And just for the record, as a father, if I'm explaining I'm losing, then I guess I'm losing all the time.
I feel the same way.
I do want to go back to the question. I also want to follow up on the Judiciary's chair about federal protection based on race and other protected categories. And I'd also point out, obviously, Loving versus Virginia.
Sure, of course.
Guarantees a constitutional right to interracial marriage.
That's a constitutional right to interracial marriage,
So I think we've sort of skipped past the notion that would ever be considered unlawful, hopefully, in our country. I want to ask you, when or which Georgians do you think should lose their tax credits, tax exemptions, or any tax preference based on their view of marriage, whatever it may be? Which Georgians do you view?
I don't think any of them should.
Which Georgians do you think should lose their job based on their view of marriage?
No, that's, I don't agree with the premise.
Which Georgians do you think should lose their public benefits or their access to education based on their view of marriage?
I think without further elaboration, I'm unable to answer your question. You know, this blanket, which Georgians thing is
Senator,
incredibly broad. There's no
well,
way I can speak to that, actually.
Thank you, Senator. I'll try. As broad as it may sound, these are the exact provisions of the bill. So these are the exact paragraphs that you'll see on lines 71 through 88. These are the things the government is prohibited from doing. Taking away a Georgian's tax credit, tax status, or exemption for charitable contributions or otherwise, employment, grants, contracts, public benefits, eligibility for education, or access to a free speech forum based on whatever their belief of marriage is.
Free speech forum, you and I are on the forum, you and I are definitely on the same page. As far as the others, look, Loving versus Virginia, you just mentioned it. There was absolutely a time when government made it impermissible for interracial couples to get married. And there may well be a time where we decide it's impermissible to withdraw, or it's impermissible for an organization to have that same viewpoint where they're discriminating against same-sex couples. And I would not like us to have in Georgia code any law that makes that day more difficult.
Where is discrimination authorized in the bill?
You may, it's choosing, it's the person who's actually acting is the one who makes the discriminatory judgment.
Based on?
Based on their view about marriage or sex.
And a Georgian doesn't have the right to hold whatever view they hold about marriage? That's your position?
I do not think that we should enshrine into law their ability to take action based on that belief, no.
Senator, I'll close, and we may be able to continue here at our seats, which
I would
I
love
do
that.
enjoy with my friend. And I'll close with this. I want to ask you if you agree with this statement, if I could. And I
Sure.
apologize, I ask your indulgence. Do you agree that each person has the natural and inalienable right to worship God, each according to the dictates of that person's own conscience, and that no human authority should in any case control or interfere with such right of conscience?
Certainly, freedom of religion is a dear American value. It is absolutely enshrined in our Constitution, but we may not choose particular religious viewpoints above others, nor may we single out religious viewpoints above secular viewpoints in the governmental space.
Senator, I told you that was my last question. I apologize. Would it surprise you that that is the exact paragraph 3 from Article 1, Section 1 of the Georgia Constitution? And I would submit to you that from the beginning of our republic, we have always protected religious viewpoints, frankly, above all others. Would that surprise you that argument is in our own state constitution?
Well, I guess it would surprise the Supreme Justice Thomas in Reed versus Town of Gilbert, or maybe it's the Rosenberger one. And again, these are intricate constitutional questions with balancing tests. What we're really talking about is the perception of what kind of state Georgia is. And I would posit to my colleagues that with all of these examples and talking about whether or not you can discriminate against people for being gay or for being single or for having gotten divorced and then remarried, because some people believe that once you got married, that's it. Even if you remarried someone else, you should not be having sex with them because that was your true marriage, right? You know, if you're talking about all that stuff, I do think we need to be very careful because, again, colleagues, if you're in this space and you're explaining, you're losing. Thanks so much.
Thank you, friend. Thank you, Mr. President.
She's yielded well. Senator from the 36 will be next.
Thank you. Colleagues, I rise to speak against this bill which, as has been pointed out, was given the most cursory amount of consideration in our committee process. Number one, it was not assigned to go to one of our full committees. It was assigned into the Rules Committee. It was in the breast of the Rules Committee for a hot minute, and the next thing you know, one meeting, a new bill version, voted on in the span of one afternoon, with the very people who were attempting to weigh in and shed some light on their issues and concerns not even having seen the version of the bill before that short debate and a vote was taken in committee. So disabuse yourselves of any notion that this massively important bill, in terms of its impact on Georgia's economy and the message that it sends about who we are as a state, disabuse yourself of any notion that this has been vetted and that the input has been made and that has been weighed and considered. It was absolutely, and as has been pointed out, this is the first or maybe the second House bill that we've even had on the floor for a vote. There was one that I think we all supported very early in the session that came over here in a hot minute. There was no controversy. You have on your desks voices of important parts of our state economy begging and pleading with us as lawmakers, do not pass this bill in its present form. And there are people in these seats, regardless of your party affiliation or your caucus membership, who know that we should be listening to these voices of reason. Your very own colleague, former Majority Leader Ronnie Chance, heads up a coalition of businesses attempting to shed light on the economic damage that can be done to this state by putting this bill into our law books, by continuing to move forward with this bill. And there are those of you who know that and understand that. I'd love for you not to stand silent. I'd love for you to at least indicate you know that by voting no on this, whether you speak or not. But you can absolutely defend a no vote on this bill. Number one, the vetting question. It was done virtually overnight. Number two, the weight of the studies that have been brought to us by members of the business community. The Georgia Chamber, the Metropolitan Atlanta Chamber, the coalition of 300 businesses that commissioned a study and brought the findings that we would damage our economy from $1.5 billion to $2 billion annually. Early in the session, House Subcommittee, hearing on the budget, the World Congress Center spokesperson was asked in open committee, on the record, if we pass RFRA, which was the bill of the moment at that time, what's going to happen to the World Congress Center, where we have sunk billions of dollars of taxpayer money, and from which much profit and benefit to our economy and job creation has come. The Georgia World Congress Center Authority representative said, oh, we will have cancellations. It will hurt our bottom line. I can tell you that. We already know of cancellations were this bill to pass. The national organizations that book conventions and move enormous amounts of money and people into our city, we see it if you don't pay any attention to anything but the traffic. They'll say, oh, there's X number of the Association of et cetera, is in town for a 4-day meeting. So don't even go near the World Congress Center. Don't attempt downtown. We're gonna have 100,000 people, and then over here we're gonna have this big, huge sports event. Folks, we're on the national stage. We are blessed by wisdom of our leadership over the years to invest it in world-class convention centers, world-class sports arenas, and we have benefited, one and all, from the business that they have generated. That's inarguable. Tell me I'm wrong. You know I'm right. You know I'm right. The dollars don't lie. We are sitting here saying we're prepared to torch that on the basis of this bill that got was it 2 hours at best in a Rules Committee? Maybe it was 3, with a version that had never been seen before, flies out of there and is on our floor today on a Friday afternoon. And we're willing to pass this and thumb our noses at our entire business community. Bring me some letters from business that are scrambling and saying, we have got to have this bill for our economy. We simply, please, you all, please bring us this bill. In fact, to the contrary, in the Atlanta Business Chronicle, let's keep Georgia welcoming to all people. The Westin Atlanta Airport, the chairman of the Georgia Hotel and Lodging Association. Numerous pieces, he says, of proposed legislation claiming to protect all manner of religious activity are unnecessary. Our state and federal constitutions, along with every other anti-discriminatory laws, protect our religious freedom very well. Remember Indiana? Bill Henderson goes on to say, last year, the Indiana legislature passed religious freedom legislation they claimed was not intended to discriminate against anyone. And within days, the impact was enormous. Within a week, Indiana's governor, under pressure from local business leaders, signed a new bill that included a clause to prevent discrimination, a clause that the promoters of these types of legislation have been unwilling to accept here in Georgia. The headlines were gone after the governor signed the new bill, but so was a lot of business from organizations that decided to stay away from Indiana anyway. This is what the senator from the 42nd was talking about perception. People are not going to be reading what's on line 72 and line 88 the way we've been debating here. They're going to know that a bill that allows state-sanctioned discrimination against gay people, and this also throws in any other kind of thing that's outside of a traditional male-female marriage, divorcees, people cohabitating, etc., that kind of bill has passed in Georgia, and that's it. The hit is on. The headlines were gone, he goes on to say, but a lot of business from organizations that decided to stay away from Indiana anyway. Indiana state leaders reported related losses ranging from hundreds of millions of dollars up to $1.5 billion. And a recent study shows the damage to Indianapolis continues today. How could the same story play out in Georgia, he asks. Well, first, Georgia would lose at least $600 million in convention business. That's not all. The loss of major sporting events like the hoped-for Super Bowl in 2019 or 2020 would cost the state more than $400 million. The Atlanta Convention and Visitors Bureau estimates that over a 4-year period, the total economic loss to Atlanta's tourism would be about $2 billion. The ripple effects would reach any and all businesses dependent on tourism. So we have letter after letter, document after document. Hilton Worldwide has their government relations person weighing in with us on behalf of Hilton Worldwide's 159 owned, managed, and franchised Georgia hotels. It's critical, they say, that you oppose House Bill 757. The Marriott, 153 managed and franchised hotels across the state of Georgia, a combined 7,800 employees. Help us ensure that Georgia continues to extend a welcoming message to all of the traveling public. Intercontinental Hotels Group. I have one of the high-up executives living in my district from this. Documents at the convention center, $450 million in direct spending per year, $400 million in business sales, $50 million in state and local taxes per year, and 4,000 full-time annual equivalent jobs per year. Are you willing to set a torch to all of this? Are you willing to pass a bill that does this to our economy? When we're just getting back on our feet? When we talk about needing to address providing jobs, stabilizing the workforce, welcoming business, being a business location for the world to come to? And you want to carelessly pass a bill like this that is murky at best. That's maybe one of the most generous things you can say about it. I want to point out to you, we had restaurant night. Didn't we have restaurant day the other day? A lot of good friends of mine. We all got great friends in the restaurant business. They may be waiting tables. They may be planning the menus. They may be funding it. They may be the chef. And we all enjoy dining at Georgia's fine restaurants. Some of us in here own fine restaurants in Georgia. The Georgia Restaurant Association states it is proud of the richly diverse restaurant community we serve and employ. In our state, we foster a welcoming dining experience for all who visit and oppose any unnecessary legislation that conflicts with these measures, thus portraying Georgia as an unwelcoming state. It's all about perception. I also think that there's some haints and boogers in the bill that's what we used to say. I've been in the House a long time before I came over here, and that was a common gentleman from the 20th. That was commonly heard from the lips of your father and many others. But there's some hidden verbiage in this bill, and I was going to ask the esteemed lawyer from the 42nd to shed a little light on it. Some other lawyers might want to jump on this, but when you look on page 3, paragraph F, and it defines an adverse action, which of course is outlawed, these adverse actions, that the government cannot deny, withhold, reduce, exclude, terminate, condition, or otherwise make unavailable access to any speech forum administered by a government, including access to education facilities available for use by student or community organization. Do you understand what that's saying? You can go and fly in the face of Supreme Court rulings and take people's religious beliefs right back into the heart of the schools, which has been for some decades now ruled to be outside of the Constitution. That's what I'm talking about when I say there's all sorts of implications in this legislation that have not been fleshed out or fully vetted by any means. Finally, I would say to you now, you know, we all heard from a lot of licensed professional counselors over the last week or two, didn't we? If you dared to open up your email box, you were flooded, weren't you? I think it was 66. This author has left the floor of that bill as well, but I think they were treating 66,000 Georgians a year. Sometimes you hesitate when you're rattling off these numbers if you don't have them in front of you. But at any rate, we know there are a lot of licensed professional counselors in the state. We know they were mighty interested in legislation up here and still are, because that bill's in the House now. You think you heard from a lot of them? Well, I'll tell you what I heard in my email box tripled what the licensed professional counselors ginned up about this bill. And I heard from Paulding County, I heard from Savannah, I heard from all parts of the state, but I heard overwhelmingly from my own district up here in Atlanta. The fear and loathing that we would be doing this with our time rather than addressing the great needs that we have as a state and the pressing policy matters that I won't list. And this is about this in terms of perception. No. Average Georgians are not going to be out there flipping through page 3 of this bill in paragraph F, but they're going to hear. What the bill came flying out of the Senate and going back to the House that protects discrimination, puts it in the law, protects discrimination. I heard from 2 Emory docs in training. A same-sex couple. We were going to stay here. We were going to make our home here. We were going to practice medicine here. If this bill passes, we couldn't consider doing that because we know what kind of state we're living in. That's one small example, but the point is there are layers upon layers if you peel them back in your districts. There are people in your churches, in your houses of worship, in your community groups, in your campaign structures, people in your offices that work for you, people that are out here in the hall lobbying, the general public. There are untold numbers of gay, lesbian, and transgendered people who are holding their breath for fear that we as a legislature are going to take this action. Because it says to them once again, you're less than. You're not protected. You're vulnerable. Good luck. But the state's not going to see that you have any protection. You're on your own. And this is after hundreds of years of discrimination. As a nation, people, we know that we're moving forward. And it's halting. It's not day-by-day forward steps. But we're moving toward fully acknowledging and upholding the concept that lesbian, gay, bisexual, and transgendered people are persons under the law with all the full protections of the law. It's called equal protection under the law. And the U.S. Supreme Court most recently made that ruling. Same-sex marriage is protected and lawful and legal and fully protected by the Constitution. And here we are this afternoon, the end of the week, considering a bill that's been hastily put together, clumsily crafted, difficult to sort out, but definitely sends the message. If you want to discriminate based on your views of marriage, have at it. The government's not going to have a thing to say about it. You're held to no standard. It's open season. That's what this bill, that's the message that this bill sends. It's open season. And I'll tell you what, the southern states fought back when Supreme Court rulings like Brown versus Board of Education came out in 1954. They stood in the schoolhouse door, massive resistance, states' rights, all sorts of theories and artfully crafted legislation to say we're not going to go with the federal law. We're not going to adhere to the law of the land. We're not going to have our behavior directed by those rulings of the Supreme Court, by those legal findings, by that understanding of our U.S. Constitution and who has a right to be protected under it. And this current pushback that we're seeing in the states is of that same, it smacks to me of days gone by. And people that have lived long enough, many of them repudiated what they did in those days gone by. But the record is clear. We hauled up a Confederate flag, you know, to show our massive resistance, and then argued that it didn't have anything to do with slavery or the Civil War or anything. But this resistance to fully accepting and integrating into our culture and our consciousness and our community and our mores and our way of life that gay, lesbian, transgendered, and bisexual people are of us, are one of us. We're all together the same. We're citizens protected by the laws of this land. That's what we need to be moving toward. And that's why, to me, this is the passion that I bring to this, and that you'll hear when you listen to constituents, is that this is onerous. This is onerous. We can be better than this. We can do better than this. This is about who we are as a state and about our values. And there are plenty of folks in the faith communities that are opposing this bill. You will see 286 Georgia clergy oppose discrimination in the name of religion. Across Georgia, clergy of every creed are speaking out against so-called religious freedom bills because the U.S. Constitution already safeguards our religious freedom. I have met with countless pastors, priests, and rabbis. They've put their names together. They've bought ads in the paper. They're doing everything in the world to say to you, the faith-based community feels you should back off from this approach. I thank you for your time and attention. I'm happy to yield to any questions. I would ask us to search ourselves, search our souls, and do the right thing. Be able to tell your grandchildren, and that day will come, that you didn't vote for state-sanctioned discrimination. You voted against it. Thank you. I'll yield for any questions.
Senator from the 22nd, you wish to ask a question? You're recognized to do so.
Thank you. Would the senator yield?
I yield.
All right, thank you. Isn't it accurate that marriage has been declared to be a fundamental right?
You are correct, Counselor.
And isn't it also accurate the Supreme Court has said that marriage is a keystone to the nation's social order?
Marriage is a keystone to the nation's social order. Did I hear you correctly?
Yes.
Yes.
And isn't it also correct that the concept of marriage, the Supreme Court has said, is one of the hallmarks of individual autonomy in our nation?
Who could put it any better?
Okay. And it is with
Marriage autonomy is a hallmark of our nation's.
and it would the senator further yield?
Yes.
And it's with that backdrop, with the Supreme Court saying that marriage is a hallmark of our nation to individual autonomy, it is with that backdrop the Supreme Court ruled that persons of the same different races could get married. Is that correct?
That's right, and that's the Loving versus Virginia that you're quoting from, is that right?
Yes.
Yes, that was in the state where I was born, old Virginia.
And would the senator further yield?
I do.
Okay. And it is also with that particular backdrop that the Supreme Court just recently ruled that same-sex marriage is now constitutional.
Amen.
Okay. Senator, further yield.
I do.
And so it is with that backdrop that same-sex marriage now must be considered to be one of the hallmarks of individual autonomy in our nation. Is that not correct?
That is correct.
And so it is with that backdrop and that understanding, would anyone make an argument that persons of the same race different races should not be allowed to be married or have that marriage somewhat curtailed just because of a different point of view?
It's hard to imagine, but I do know that there are people who hold as their religious conviction that people of different races should not be married. I do know that.
And would the senator further yield?
Yes.
And would you also agree that because it is a fundamental right that the Supreme Court has said that whether one business closes or 1,000 business closes, because it is a fundamental right, that this body should not try to hamper that particular right regardless of what impact it may have on business, whether it's 1 or 1,000 businesses that may close or leave Georgia?
I would agree with the senator from the 22nd.
Okay. Thank you. I have no further questions.
Thank you for that question, Senator. If there are no further questions,
You do have more questions if you wish to.
I will entertain a question from my chair lady.
Well, the senator from 39th's got
Oh,
his
fine. No, yes, sir.
light on first.
Will the senator yield?
I yield.
I want to finish out or round out your discussion of the financial impact of what we do here today. And my question is, you did make reference to losses of financial sort that occurred in Indiana, and my assumption is, I think your line of thought was that that same loss would occur here in Georgia. Is that correct?
That is the concern and the fear, Senator, that have been expressed by so many leaders in our business community, yes.
And if the senator were further yield,
I yield.
are you familiar with the argument that some have made, even on this floor, that since Arizona had a RFRA type bill and there was no boycotts there, are you familiar with the argumentation that we would not get a similar boycott or loss of financial revenues here? Are you familiar with that argument? Have you heard it on the floor?
I've heard it said. I don't give it any weight because you can look at the facts and the figures and the numbers from our own business community that contradict that.
Will the senator further yield?
I yield.
Is it not true that the lack of a boycott or an increased fiscal impact in Arizona occurred before the Supreme Court decision on marriage equality? Isn't that not correct?
You're right. That is correct. That was the chronology of events.
And will the senator further yield?
I yield.
Is it not true, and you did not use the word boycott, I'm using the word boycott, but the implications of your debate imply that an action would be taken? And isn't it true that in the context that we are living in now, after the Supreme Court case on marriage equality, is it not true that regardless of what one might think or wish or want, that a national boycott of this state will happen if this bill is passed, if it's passed by the House and then goes to the governor's desk? Isn't it not true that we are facing a hurricane of boycotts, national boycotts called by national organizations of a sort that will hurt the economy that so many people on this floor purport to support?
Senator, you make an excellent point, and I appreciate your further delineating. The obvious end game here is that this state will be targeted Business will be withdrawn. There will be a national boycott campaign. Organizations will be asked to not bring their business and their dollars and their members to our state and to our economy. That's absolutely right.
Will the Senator yield for one more question?
Thank you.
Is it not true that this impact will not just be City of Atlanta? It will not be just Metro Atlanta, although it will be serious impact, but that it will have an impact on all of Georgia. It will have an impact on other cities. It will even have an impact on rural areas whose products that are exported to other states are not accepted. That is to say, is it not true that the impact of a boycott will have a statewide impact that will hurt our citizens? We will lose jobs. There will be a perception out of abroad in the land, not just here in the state, but in the United States and internationally, that Georgia discriminates against certain people and therefore is not a state that people want to do business with. Isn't that true?
Senator from the 39th, you're absolutely correct. I completely agree with you, and that is a grave concern. And as much as loudly as you and I may proclaim it, don't listen to us. Listen to the experts who live this every day, and that is the number crunching of how to keep our economy moving forward and how to keep the business flowing, how to keep the dollars, the clients, the customers coming to Georgia as we continue to invest in our world-class airport, as we continue to build out all across this state opportunities for attracting business and attracting tourists and attracting a favorable image. And you know the irony, good people, of all of this? This is the home and birthplace of Martin Luther King Jr., whose entire life's work stood for brotherhood and equality. And in today's parlance, we would add sisterhood as well. But Georgia's on the map internationally, nationally and internationally, as the home of Dr. Martin Luther King. I'll be bringing the pastor from his home church to pray with us in the coming weeks. We are on the map for having that kind of reputation. The birthplace, cradle of the civil rights movement, human rights movement, equality, justice, freedom, inclusion. And that's the choices that we have. That's the two roads we can go down. We can pick a road to go. We can go down the brotherhood and sisterhood road, or we can go down the exclusion and division, which is never a winner. You have every good grounds on the economic basis alone to vote against this bill, and I would urge you to seriously consider that. I'll yield the governor. Thank you for
Your
the
time has expired anyway. That was 30 minutes in the well there. The minority parties asked for 10 speakers, and 2 of them have taken an hour. Yeah. Chair recognizes. Chair recognizes the senator from the second for 3 minutes. What? Or 5? 5 for him, 5 minutes.
Thank you, Mr. President. To my friends in the Senate, I rise in opposition to House Bill 757. I want to tell you a little story. It's printed in the Atlantic Business Journal by a young man by Bill Henderson. Now, Bill and I really don't know his party affiliation, but he sounds like a great Georgian and a pretty good guy. And this is what he says in this opinion page in the editorial. Let's keep Georgia welcoming to all people. Georgia is a beautiful and welcoming state. It is vitally important it remains that way. Religious freedom is not threatened in Georgia. What is threatened is, if irresponsible legislation is passed, is the economic future of many hardworking Georgians who have served visitors in hotels, restaurants, stores, and attractions across this state. It's really that simple and that alarming. Numerous pieces of proposed legislation claiming to protect all manner of religious activities are unnecessary. Our state and federal constitutions, along with other anti-discriminatory laws, protect our religious freedoms very well. Legislators need to understand there are real, immediate, and long-lasting consequences if legislation is passed, no matter how well intended, that could be used to discriminate against certain people. This is not speculation. They cannot dismiss the numbers. Remember Indiana. Last year, Indiana legislators passed religious freedom legislation they claimed was not intended to discriminate against anyone. Within days, the impact was enormous. Within a week, the Indiana governor, under pressure from local business leaders, signed a new bill that included a clause to prevent discrimination. The headlines were gone, but a lot of businesses and organizations that decided to stay away from Indiana stayed away. Indiana state leaders reported losses ranging from hundreds of millions of dollars up to $1.5 billion. In a recent study shown the damages of Indianapolis still continues today. It further says that the easy path to take is to dismiss the estimate and charge forward. But doubters of the data should look at what happened to Indiana and ask, is it worth it? What will be gained? The answer is nothing. Our religious freedoms are already well guaranteed. The bills before the legislature may not have been introduced with discriminatory intent, but it carries an effect that far long in Georgia. Let's work to keep Georgia beautiful and welcoming to all people. Now, that was an editorial, but the real fact is that economic development is alive and well in Georgia. Tourism is alive and well in Georgia. Why should we affect economic development? Why should we affect our tourism? Why should we be about the business of hurting people, not even if it's the intent of hurting people, but if they feel that way? Why should we introduce legislation that go against the fundamental right of people to live in this great state? Let's vote against 757, House Bill, and let's continue to let Georgia grow and prosper. Mr. President, if there are no questions, I yield a well.
Chair recognizes Senator from the 40th.
Thank you, Mr. President. You know, I've been down here 18 years, and one of the things that I guess I would describe myself as fiscally conservative, probably socially moderate compared to most of my peer group in the Republican Party. But I will tell you, some of the comments I've heard today are a little bit disturbing. I never thought after the 18 years I've been here that I'd hear the lady from the 36 defending big business. That was a rather unique opportunity to hear that. That was a first for me. But, you know, I look at this bill, and I think this may be the first time in the state of Georgia since the Supreme Court ruled that we've actually talked about lawful marriage being between two people, not just a man and a woman. I have my own personal opinion. I still believe that very strongly from a religious conviction standpoint. But this is a law of the land, and we're to uphold the Constitution. And I don't have all the Supreme Court cases down here. But I do know this. I've watched this debate since the gentleman from the 29th basically started this in the past year. I watched the gentleman from the 13th here work very, very diligently. I want you all to remember something here. This language, between two people, that's a big thing in this state. To say that we've got people on this side, traditional marriage, and people over here with same-sex marriage, and we're going to treat both sets with mutual respect. I don't know about Supreme Court cases, really don't care about all the cases that they're talking about. Their perception is what we make it here. This is about state government, adverse actions by government. It's not about discriminations by this guy or because some clerk doesn't want to give a marriage license. That's not allowed in this bill. So let's remember what we're really talking about here, okay? When I get phone calls from my daughter, Daddy, you're going to vote for that discriminatory bill? You know, shame on us because we let the media define what we're doing down here. Read the bill. Look at what it says. What we're going to do with this bill, and it will pass, I have no doubt about it, it will pass and it's going to go over there, okay? And we're going to see what they're going to do, and the dialogue continues. So let's be perfectly straight about what's going on in the bill. That was not a pun, I might add. Okay? And let's move forward. Thank you, Mr. President.
Chair recognizes Senator from the 10th. Three.
Thank you, Mr. President and colleagues, and to my friend from the 40th, I have read the bill. As a matter of fact, there's several areas in this bill that the author couldn't quite understand or explain in great detail, and that in and of itself should give all of us concern. Anytime you have a loose definition of faith-based, and I mean very, very loose definition in this particular bill, it opens the floodgates for just about anything and anybody. That's exactly what we're doing here in this state. We're opening the floodgates. But you see, I didn't come up here to talk about just the discriminatory language in this bill. I came up here to talk about how some CEOs somewhere in this world, somewhere in this country, and perhaps somewhere in this great state is thinking about where they're going to locate their business or relocate their business. And I hope you feel as I do that I'm concerned about what the headlines are going to be tomorrow. How this state is going to be portrayed publicly, because that's what a lot of people depend on when they make business decisions. Anytime somebody is looking at this great state, they're concerned about not just our business climate. They're concerned not just about our academic institutions and that legislative environment, but they're also concerned about how well this state treats its people. And when I look at this legislation, I can tell you that I would be very, very concerned if I was of a particular class who's being impacted significantly by this bill, how the state that I love so much is treating me. Folks, that's just outright discriminatory. But perhaps there's some in here that don't mind, because Georgia has a long, long history of doing just that. And it's sad as a legislator to see that history perpetuated in this chamber in this year. Folks, if we could play games and wonder what would happen if, And you can fill in that blank any kind of way you want. What would happen if this legislation actually passed? What would happen if someone went out and sued the state? What would happen if? And I suggest to you that that's a very, very dangerous game that we should be playing with the people of this state. And my colleague from the 40th was probably correct. This legislation will pass, and that's the saddest part about it, because as I've mentioned previously, I'm under no illusion as to who's supporting this legislation. But what's really, really sad is that the headlines tomorrow would not favor a positive vote for this particular legislation. That's what I'm concerned about as a person who staked his family's future on doing business in this state. That's what I'm concerned about when I've staked the community of which I serve and represent, and the future of all those that I serve on this state. That's what I'm concerned about. I just wished to all of my colleagues out here that so many of you shared those same concerns. And I know you do, and I know you do. If you do, then you would be terribly, terribly concerned about the language that's in this bill. And I hope I have another 30 seconds left, Mr. President, because my colleague from the 40th said, if you read the bill. And I did. I read line 89 that says a faith-based organization means any organization or other legal entity whose governing documents or simply a mission statement expressly acknowledges a religious belief or purpose. You don't even need a governing document. You can simply have a mission statement. And all those legal minds that we have out here, I wish you all would ask me how quickly those mission statements for a particular organization can change, because those I've been affiliated with, they can do it overnight. My colleague from the 40th asked if we had in fact read the bill, and he said read the bill. So, Mr. President, I have to take an opportunity to read this bill, and I read line 54 of this bill on page 2, and it said, no religious organization shall be required to rent, lease, or otherwise grant permission for property to be used by another person for an event that is objectionable to such a religious organization. And I know in this state that a lot of religious organizations, including my church, owns a lot of real estate. We own a lot of property. We own even private care homes for the senior citizens. And I can just see how some groups can be impacted by this language shall not be required to rent, lease, or otherwise grant permission. And I would say to not just my colleague from the 40th, who we share a county together, perhaps he should reread this legislation. And thank you, Mr. President. And if there's no questions, I yield for the questions. Otherwise, I yield away up.
Chair recognizes Senator 29th for a question.
Well, Senator, yield.
Absolutely.
Senator, you're expressing concern about the language contained in lines 54 through 56 of the bill. Are you concerned about that?
I'm concerned not just about that language, Senator. I'm concerned about the entire bill. And not just, I highlighted that language because I just happen to have a couple of asterisks beside me. And I hope that you will be concerned not just about that particular language on those lines, but everything else that's in this bill.
Will you further yield?
Absolutely.
You are aware that the language contained in lines 54 through 56 are part of the original House Bill 757 that passed 161 to 0?
Senator, what do I have to do with the House? I don't care what they do over in the House and how many of your colleagues or my colleagues supported legislation over there. I vote my constituency.
Did you also express in your, will you further yield?
I'll yield all night for you, Senator.
Did you also express some concern about the economic impact of passing this legislation?
That is correct.
Are you aware of the decision by Volvo Motor Corporation to locate a facility in the southeast late last year?
Senator, I'm aware of not just Volvo, I'm aware of General Motors and the plants that have opened. I'm aware of the details and the information that the Senator from the 39th just provided us. I'm aware of a whole lot of things.
And are
yes.
you're aware that the two finalists were Pooler, Georgia, and North Charleston, South Carolina, a state that has South Carolina being a state that has one of the most strict religious freedom laws in the nation?
Senator, I'm not South Carolina. I don't care about South Carolina. Let me tell you who I care about. And perhaps you didn't hear my argument, but I'm concerned about where I live. I'm concerned about this great state, and perhaps any of those other states may have a language that's objectable to me as well. But I'm not here fighting for South Carolina. I'm fighting for Georgia.
And are you aware that Volvo Motor Corporation made the decision to locate their factory and make their capital investment and bring jobs to North Charleston, South Carolina, a state with one of the most strict religious freedom laws in the nation?
I am aware of that information, that they chose not to relocate here in Georgia, and all of the reasons why. Perhaps we could consult with the governors and economic development to find out the other particulars about why they made that decision. I'm sure that wasn't the reason why they made that decision to relocate, because of their, quote, discriminatory and restrictive policies. It's got to be something else.
And one last question. Are you aware of today's announcement by Remington Arms to move 2,000 jobs from the state of New York to the state of Alabama, which also has a very strong religious freedom statute in place?
Have not read the business section today. Didn't been too busy up here looking at this bill.
Thank you, Senator.
You're more than welcome.
Chair, no further questions, Senator. No
Thank
further
you, Mr.
questions.
President. I yield.
Chair recognizes Senator from the 19th.
Thank you, Mr. President. It's been very interesting to listen to the debate on both sides. What I learned from listening to the debate is there's a lot of fear on both sides, and I think that's, other than the bill, there's the impetus for the discussion is one side is afraid of the other, and the other side is afraid of the other, and so we're passing a law to deal with that fear. Some of the fear is founded, some of it's unfounded. I think the bill actually addresses the fear that exists on both sides. On the side of those who believe in same-sex marriage, I think their real fear is these radical Christian pastors are going to somehow so speak against them that they just don't want them to have the right to do that. They just don't want them to be out there talking about their religious beliefs, which are that a man and a woman should constitute marriage. I just want to try to speak to that fear a little bit. Those pastors, and I've got two brothers that are pastors. And you know, when Roe v. Wade was passed years ago, most of the population didn't agree with the Supreme Court decision, but you could take your opinion on either side. And to this day, we still argue those opinions. And both sides, while they differ, those opinions are respected. But my brothers who are pastors are afraid that they are going to be persecuted. Now, whether that fear is justified or not, they actually believe that the other side intends for them not to have a voice anymore. And that's a legitimate fear they have. I know my brothers well. They're some of the best people in the world, but they do fear that. So I want to just try to clear up what a radical Christian really is. What a radical Christian really is. Because that's what the other side seems to be afraid of. A radical Christian is somebody who actually loves their enemy. A radical Christian is somebody who's instructed by their leader to pray for the person who despitefully uses them. A radical Christian is somebody who believes you do unto others as you would have them do unto you. A radical Christian is somebody who believes that they should have their minds renewed to believe in kindness and goodness and gentleness and humility and self-control. They're also somebody who believes, as a radical Christian, that they should control their tongue and that they should obey the civil laws and that they should judge not. A radical Christian is someone who believes in the parable of the woman caught in adultery. A radical Christians do not believe that they're righteous or that anybody is righteous. So I want you to know who you fear is really not somebody to be feared. Now, there are a lot of lukewarm Christians out there, frankly, that you ought to fear. But it's not the radical pastor out there who happens to believe that marriage is between a man and a woman. I've had an opportunity to travel around the world and live around the world. Back in 1979 through 80, when I was 25 years old, I had the opportunity to teach on a kibbutz to Jewish people who were born right after World War II. This was a great opportunity. I was an art teacher in the kibbutz, and I had all these Jewish people that had come out of Eastern Europe. Most of them, their parents had lived through the Holocaust. And after a period of time, this one woman named Sarah says to me, she said, "Tommy, you know my parents taught me never to trust a Christian." She said, "But now that I've met you, I'm not sure they were right." And I thought, well, I'm glad you haven't met some others that professing Christians who don't act quite like they should. But what that said to me is people can perceive based on, and I will tell you this, the church has not had the best history. But those who truly follow the teachings of Christ are not to be feared. They're humble, they're gentle, they're quiet, they're compassionate. They may disagree, but now those pastors that I'm speaking of are afraid that they will be silenced, and they're asking for this bill. In the bill, the author goes far enough to give everybody the same protection. Some years later, I had the chance to teach English as a second language in China. One of my students, and what an experience, because, and this was before I got in politics, but for one time I saw what it's like to not have freedom. They couldn't choose their job. They couldn't choose where they lived. They couldn't choose who they married. They could only have one child. They could not choose to have a second child. And I'm thinking, man, what it's like to live in America. So when someone starts to lose their freedoms, their ability to speak their mind on a religious matter, I'm going to stand up. We're standing up. You're taking one side. We're taking the other. But this is a legitimate debate. And I will just tell you this. When it comes down to football or religious freedom, I'm on the side of religious freedom. I'll tell you, the folks, the 20-something seminary graduates that were writing the Declaration of Independence knew if they signed that document along with the rest of them there, that all economic income from England was going to be cut off. And they made the choice to choose liberty over wealth. Those men in Boston dumped a very valuable load of tea in the water for liberty. This is about liberty for people who believe that marriage is between a man and a woman, and those who believe that it's between two people. when I was teaching in China, I had a young Chinese girl that wanted to wait every day after class. She wanted to walk with me home. And she would ask me questions about my religious beliefs. And so I would tell her every day a little more about what I believed. And I know I'm going over, Governor. But she didn't understand how an educated person could believe there was a God. So I was coming to the time I had to leave, so I left China, and because I didn't have more time to spend with her, I left her a little green Gideon Bible. And she read that Bible through and through without anybody telling her what it should mean. So then she writes me later and she says this. She said, I read your little green book. It can make me calm, tolerant, and delighted. People of faith that are often feared and are feared in this legislation should be people that are calm, tolerant, and delighted. Now, she did get to come to America later. She asked me to send her an Old Testament, which I did. She was a biology teacher. She wanted to know what the Bible said about how the world was created. I sent her an Old Testament. She comes to America, moves to Starkville, Mississippi, and she writes me a letter from Starkville, Mississippi. She says, Tommy, where can I find a Christian in America? I pass by their churches. I see their cars parked on the outside. I'm wondering what they're doing on the inside. Do they really know God's love? Very convicting. We have a responsibility as the people we're protecting in this bill and people of faith that we be tolerant and that we follow the teachings of the one who we say we're following. And if we do that, then there's no reason to be afraid of the other side, whichever side you're on. Thank you, Mr. President. I yield the well.
Chair recognizes Senator from the 38th.
Good afternoon, colleagues, Mr. President. I rise in opposition to House Bill 757. This First Amendment Defensive Act is RFRA on steroids, and unfortunately, it is also state-sanctioned discrimination. After going through this divisive debate last year, here we are again staring down another controversial religious exemption bill. Why is this body being so partisan when our counterparts in the House approach this issue with compromise, unity, and common sense? The Speaker of the House encouraged members of all faiths and opinions on religious liberty to support something that does not divide us. And the bill received unanimous support for the hard work that effort entailed. Religious liberty is fundamental to who we are as Americans and Georgians. No matter our beliefs, it is central to our values. However, our sacred religious liberty cannot come at the expense of treating anyone differently. It does not circumvent the rule of law. Religious liberty does not justify treating the LGBT community differently than others. Religious liberty does not mean closing adoption services to loving parents. It does not mean denying people medical care or services. Religious liberty does not mean closing the doors of a homeless shelter or a rehabilitation center. And religious liberty should not be an excuse for refusal of domestic violence resources. It's important to listen to our job creators and to learn from the mistakes of our friends in Indiana. Discrimination is bad for business. Why would we do anything that hurts job creating in this state? The economy and the reputation of our state is a very precious thing. We cannot be so reckless as to pass something that would send the wrong message about our state and its citizens to the rest of the nation and the world. Enshrining discrimination in the law books of Georgia is no way to attract talent. Controversial bills that yield embarrassing headlines is no way to enhance the brand of our state. This is a thoughtful approach to this issue that happened in the House just recently. Unity, transparency, and common sense. We have come too far over the past few years to allow this divisive bill to stop us from doing the work we were sent here to do, representing and protecting the viewpoints of all Georgians. Thank you, Mr. President. I will yield the well.
Thank you, Senator. Chair recognizes Senator from the 44th.
Thank you very much, Mr. President. Senators, I rise today in opposition to this bill, House Bill 757. When we talk about religious freedom, faith, and respect, I think it's important to talk about the central aspects of my faith. I'm not sure about this radical Christian, but the golden rule, treating others as we want to be treated. That's what I'm talking about, the golden rule. We learned this early in our lives, in Sunday school, in Brownie Scouts, and Girl Scouts, in Bible study, and in Vacation Bible School. The golden rule, treating others as we want to be treated. Now, my faith does not support treating people differently. My faith does not support refusing to service to others. My faith does not support creating an entire protected class of people that disagree with the Supreme Court's marriage decision. When it comes to being able to earn a living, having a place to live, or being served by a business or government office, everyone should be treated like everyone else. The supporters of this legislation do not have a monopoly on Christianity. As all of us in this body have seen, many faith leaders from all faiths, from the Methodists, Baptists, Episcopalians, Presbyterians, and the Jewish faith leaders, have come to this Capitol to voice their passionate opposition to this First Amendment Defense Act. They are the experts. They practice the First Amendment every single day. Religious liberty is a part of their daily lives. They did not ask for this legislation. They see its divisive implications. We should remember their voices today. Let's unite people, not divide them. There's been a lot of talk in the political news recently about building walls. A certain candidate for president has been talking about that nonstop, just over and over and over again, talking about building walls. Well, what we are doing here today is walling off people who believe a certain thing away from the rest of the society. That's wrong, and certainly not the teachings of my faith. Think about your own faith today. Do the right thing, because this is pure discrimination. You can try to get around it all day long, but it's still discrimination. I just had a constituent to call me a few minutes ago to tell me about this bill and try to stop some of the discrimination here in the Georgia State Senate. So colleagues, I urge you today to oppose this bill. Please vote no on House Bill 757. Thank you very much, Mr. President. I yield the way on.
Chair recognizes Senator from 34th.
Thank you, Mr. President, members of the Senate. This new version of the House Bill 757 is a perversion. It perverts our Constitution in so many ways. But in the end, it's not about free speech or religion liberty or live and let live. It's about money, 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 money. This is about letting people, businesses, and even so-called faith organizations that receive government funds for social service programs to pick and choose who they will serve with our taxpayer funds. It's hidden in the poorly written language of the bill. It's hidden in many, many words that twist and turn the rules. It is hidden in some of our words that should be clearly spelled out in this bill, but aren't. We have a state constitution that prohibits the use of taxpayer funds for religious purposes. We've been going down that slippery slope for years. We've offered tax credit to people who donate money to religious schools. We outsource programs to nonprofit organizations with a religious point of view right now. And still we go on. Now we don't even want to require that those organizations funded with taxpayer money be legal 501c3 organizations so that we can know who they are, how they spend our money, and ensure that everyone they serve with our money gets treated fairly. No matter who they are, what they look like, what they think, it's our money. This bill moves to dial in a very troubling direction. We hear a lot from this crowd about the Constitution, that we need to protect and honor the principles of the Constitution. I couldn't agree more. But don't wrap yourself up in the words that one say and then support legislation that scuttles the traditions. It's not honorable. It's not good. And it sure shouldn't be in Georgia. I won't support this bill, and I encourage you not to support it either. Thank you, Mr. President. I'll yield the well.
Chair recognizes, yeah, you sure did. Chair recognizes Senator from the 55th. You waving off? Huh? Or yes or no? Yeah. You're recognized.
Thank you, Mr. President, members of the Senate. Today I rise in opposition to House Bill 757, and I wish you could see how the senator from the 13th and the 40th are looking at me. I know you're not surprised. As I was sitting listening to many of you, especially the senator from the 36th, And she talked about discrimination. Now, you know I know what that means. You know I know how that feels, don't you? And every time we talk about discrimination, it reminds me of different incidents, not the same one, but different ones, many ones. As I was growing up, I was told I couldn't go to Woolworth. Can you imagine that? And sit at the counter to eat. But then when I finally went, I was disappointed. The stools were raggedy, the food wasn't good. But it wasn't even about that. It was about the color of my skin. I worked at a department store once. In my position, I was a clerk. I got to make sales. And the people there liked me so much, they told me I was one of them with a deep tan. Sure, how about that? But you know, discrimination is wrong. It's wrong. It's just plain wrong. And today we'll be voting on a very important piece of legislation. But the most ironic thing about it, this legislation does not raise the minimum wage, nor does it expand health care, nor does it fully fund our schools. But instead, this legislation is important for a darker reason. It's important because its passage would send a clear message to the hundreds of thousands of Georgia citizens, telling them one thing: they are not equal citizens in the judgment of this state. Discrimination is wrong. The First Amendment Defense Act would allow those who harbor prejudices to discriminate against not only the LGBT community, but as we have seen with other bills that have been presented unending over the last year, but would harm single mothers and unwed couples as well. There are dozens of legislators in this body who have apparently decided that the freedom to discriminate is more important than equal protections for all Georgia people. Just this week, those same legislators came to the conclusion that gun dealers are in need of protection. Georgia is now closer to a protected class for gun dealers than we are for LGBT citizens. Just think about that for a second. It was only last year that gay marriage became legal in Georgia. It was only last year that it was illegal for LGBT Georgians to express their love and commitment for one another through marriage. It is abundantly clear that our LGBT families are the ones in need of defense, not those people who want to discriminate against them. Just ask Robin Shahir, who had a job offer from the Georgia Attorney General's office, rescinded because of her sexual orientation. Just ask Vandy Beth Glenn, an employee of our very own General Assembly, who was fired and decried as being immoral because she revealed that she planned to transition from a male to a female. These are real people who experience real discrimination in and by the state of Georgia. Fortunately, both Shahir and Glenn sued and ultimately won, only because they wanted to be treated equally. But it took years of their lives to make only a few small steps toward being recognized as equal citizens in this state. No one in Georgia should have to spend years fighting for basic equality under the law. Every single person should be born with equal rights and equal protections. Instead of moving forward and transforming our state into a welcome home for all types of people, we repeatedly find our state falling backwards from self-inflicted wounds. The sanctity of religious freedom is not in danger and absolutely must not be used as a shield for state-sanctioned discrimination. I bet you there is not one speech that the governor makes and does not say that this state is the best state to do business. The First Amendment Defense Act is an important piece of legislation because it presents an opportunity for Georgia to send a message. Do we send a message to the world that Georgia is a great place for you to live, work, and raise a family, whether you're gay, straight, transgender? Or do we send a message to the world that Georgia is a great place for you to discriminate and practice your prejudices? The answer to that question will clarify the nature of Georgia's heart and soul. I refuse to believe the nature of our state is so dark, and I hope to see all of my colleagues join me in embracing the light in voting against this bill. Mr. President, thank you. I yield the well.
Okay, that's fine. Let's see, my understanding is that Senator from the 39th will go, and then the Senator from the 41st will be last. You're recognized this time, Senator from the 39th. Who does? Senator from the 35th, what's your light on for? Ooh, ooh. Boy.
Mr. President, members of the Senate, I will try not to be repetitive, although some things do bear repeating. Senator from the 55th was very eloquent because she made it very clear that you have to know what discrimination feels like in order to understand why people might have concerns when you've been discriminated against, when you've known the humiliation and ignominy of being discriminated against, then you can understand why people have concerns. I have already made the point by questions to the senator from the 36 about the fiscal impact of this bill and the coming boycott. And you can talk about Alabama and South Carolina all you want. South Carolina, Alabama is not, they are not Georgia. Georgia is different from Alabama and South Carolina. And if you think that there's not a boycott coming, I'm not going to debate you. I'm not going to argue with you. Just wait. There's going to be a national boycott of Georgia if this bill passes and becomes a law. Whether it remains law is in question. I am not a lawyer, but I have been told by lawyers that this bill, if this was to become law, that it would not be viable before a federal court. We'll see. If it does not become law and we get a boycott, that will be a double whammy. To pass a bill, it's found unconstitutional, and then what? Then you get a boycott anyway. I mean, it's Indiana Redux. But there will be a boycott. You can whistle past the graveyard if you want, but it's going to happen. One thing I do want to say is, in defense of my hometown, Atlanta, Atlanta has a public accommodations law. I don't know. I think many of you may know that. You may not know what it entails. And I'd like to read from the law. The Atlanta Public Accommodation Law says that a public accommodation shall mean and include any place, legal entity, store, or other establishment, either licensed or unlicensed, which supplies goods or services to the general public, and shall include but not be limited to the following types of services or facilities: hotels or other establishments which provide lodging to transient guests, restaurants, cafeteria, lunchrooms, lunch counters, soda fountains, and other facilities principally engaged in selling or offering for sale of food for consumption upon the premises, financial and brokerage institutions, insurance carriers, motion picture houses, theaters, etc. The fact of the matter is, if this bill passes, that would eviscerate Atlanta's public accommodation law. I find that objectionable, but I had to come to this well and say that this bill does away with any local ordinances that protect against discrimination. I also want to speak to this issue. The senator from the 10th talked about the KKK, and I know there's been, and any time although I don't think one should ever take an opportunity, whether they disagree or agree, in a discussion of the Klan to say, to kind of throw it away as if it's not something to be dealt with. The fact of the matter is, and I will say this, that there are white supremacist movements in this country which have a religious basis for their philosophy. Christian Identity Movement is one of them, which uses race as a distinguishing factor in their religion. It's a religious organization and with a ministry. And so I don't think it's far-fetched to see at some point in time that there will be religious organizations that discriminate based on race because of this kind of bill. It's not far-fetched. I don't know about the Klan, but there are those organizations, those religious organizations that use race in their theology, if you want to call it that. As I close, I do want to quote from a letter written by an attorney, very good attorney, used to lobby down here and is now in Washington with the Americans United for Separation of Church and State. And this is her analysis of this bill. And it's been referred to indirectly, but she writes, thus any person, business, or taxpayer-funded organization could, under this bill, refuse anyone else rights, services, and benefits because they are part of an interracial couple, are part of an interfaith couple, are a single mother, are part of a same-sex couple, are divorced, are remarried, live or have lived with a partner without being married, or have had sex outside of marriage at any time in their life. So I would just ask you to remember that, everything else aside, that this bill is a license to discriminate. It's a license to discriminate not just against the LGBT community, and that's bad enough, but it would be a license to discriminate creatively against others. And that is what we do today. But while it may be resolved for a while, it will not be reserved finally. This is not the end. this is just, I think, maybe the end of the beginning, but this issue will continue to plague us until it is made right. Members of the Senate, Mr. President, I'll yield the well unless there are questions, and I'd be glad to take those.
You do have a question from the senator from the 54th, if you will yield.
Yes, sir.
Mr. President, will my friend the whip yield for what I think will be a brief series of questions? I hope.
I've heard you say that before, but I'll be glad to yield to my friend from the 54.
I won't turn my page, Mr. Whip.
Okay.
Would you agree with me that the Supreme Court of the United States has ended the legal argument over whether same-sex marriage is legal in this country?
I would agree with that. I think they have. Although, you know, I'm going to remind you, Senator from the 54th, I'm not a lawyer. I'm a lowly classroom teacher.
With all due respect, you're not lowly, and classroom teachers have proven to me many times that they know quite a bit. Would you also agree with me then that same-sex marriage is legal after the Obergefell versus Hodges decision?
Yes, sir. Absolutely.
And am I correct that you agree with that opinion?
Yes, I do.
Do you also agree with the portion of the majority opinion that asserts that while the legal argument is resolved, the social argument should continue and be protected?
You know, and if I'm sure you're quoting correctly, but it brings to mind Brown v. Board of Education. In that decision, the Supreme Court said that the issue of whether or not African-American child would be allowed in integrated settings, that's resolved, but there were a lot of things left to go. And then they said in 1955, we want to go slow on this school integration thing because we need to allow the people who are against it to catch up. I think that in the same context, the marriage equality decision, very important decision, but we should not take into consideration the fears of people who are against it over the rights of the people that are affected. I believe that because there's historical precedent where African Americans were given rights in the Brown v. Board of Education decision, but their advance was put off because we didn't want to upset the people who were against desegregation.
Thank you, Senator. And to that extent, I can tell that you agree with Justice Kennedy because he referenced that exact same chain of cases in Obergefell and specifically jettisoned and said we're not going for an incremental or we're not doing for any. But he then, after having held so, he tells us, finally, it must be emphasized that religions and those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that by divine precepts, same-sex marriage should not be condoned. And in the same paragraph, he says, in turn, those who believe allowing same-sex marriage is proper or indeed essential, whether as a matter of religious conviction or secular belief, may engage those who disagree with their view in an open and searching debate. And isn't that the majority opinion that Justice Kennedy
And
delivered?
you know, we've gone over to I think we're leaving the law and getting into philosophy. The only thing I will tell you, Senator from the 54th, and I believe this deep in my soul, is that the fears of people, the fear of marriage equality, the fears of the people who oppose that decision should not be used as the way as justification for discrimination against people who would avail themselves of that precious right. Fear is not an excuse for discrimination.
Thank you, Mr. Chairman. May I ask you, if not fear, would an individual's liberty be worth protection from the government?
I would agree with that. I think, you know, religious freedom is an important precept in this country, but not to the extent that it allows us to discriminate against our fellow citizens.
Thank you, Senator. One final question.
Yes, sir.
If I have the liberty to believe but not act for fear of government reprisal, do I have the liberty at all?
I believe that one has the right to believe, but that right to believe in the fear that right to believe is under assault is not justification for discriminating against Georgians. That's what I believe.
Thank you, Senator. Thank you, Mr. President.
I appreciate you
No
so
further
much.
questions.
Thank you.
Chair recognizes Senator on the 41st on the minority report.
Mr. President, members of the Senate, I come to you today to talk to you about the committee process and report out of the minority members of the Senate Rules Committee. First of all, I would like to bring up the background to the committee where we held the vote on the House Bill 757 with the attachment of the FADA language. First of all, when FADA was introduced, we had a number of committee meetings. We were told we would act on FADA at one, and a large number of public advocates turned out to talk and inform us of their positions and information about the bill. That meeting was postponed a few hours, and we were asked to come back to rules. Tens of dozens of people came back to the committee meeting to discuss and be able to interact with their legislators. That meeting was canceled. Another meeting was scheduled where we were going to have FADA come up and be discussed, and dozens of activists and citizens came to interact with their legislators to discuss the issue. That meeting was canceled. Numerous times we had the meetings where we were told we would act on the First Amendment Defense Act. And many times advocates came and were not able to speak because we put it off. There was a meeting where we had a brief discussion of FADA, but it was not a meeting to pass the bill, and many of the advocates weren't there. The day that the House bill came over, we were told that FADA would be attached to it, and at the meeting, we had the bill and the amendment available for the first time for the general public. People who came to the committee to discuss this issue had not seen that combined bill. And as you all know, we are the people's legislative body, but we act best when we hear from them, and the minority members of the committee object to the fact that we're moving forward with this legislation now that without what we feel was proper public input and a fair amount of time for public to resolve their thoughts and give us their opinions in the committee process. As you can see by the minority report put upon your desk, there are many issues of contention. And some of the minority issues, such as $1 billion in business because of religious freedom issues or others, while debatable, are certainly a great concern. In the minority report, you may see where the U.S. senators, both Republican U.S. senators, said this should be handled at the federal level. Might be debatable, but I think it's an important point to note. But what we must note here today is that we are dealing with only those entities receiving state funds. Now, under the pastor protection law, we of course are saying, we can't say you have to marry two same-sex couples, or you don't have to rent your facility to same-sex event. That already is permissible under law. And the author bill says there's no law specifically authorizing it until this is passed. I think we all know we're not passing thousands of laws to cover every activity. This is a response to a Supreme Court decision. This is a response to a specific issue. And to say there's no specific law allowing it, I think is disingenuous. What we know, this is a law crafted so that people who have state contracts, people who receive my taxpayer dollars, the taxpayer dollars of gay and lesbian and other Georgians, the taxpayer dollars of good Christians and other Georgians, all of our Georgians' tax dollars will go to different programs. And under the present system, we can deny a contract or advance a contract based on evaluation of whether or not it's doing the best interest for the state. We could allow a Christian adoption agency not to have gay couples adopt if we feel that that population is presently being served by other providers. But what this law will do will say that we can no longer make that decision because we have protected and given a cause of action and waived our sovereign immunity to a certain extent to allow them to be protected because of this religious belief, which is all about discrimination. And I think that it is, as we do know, two groups of people that have concerns and have had positions and that we are all concerned about. But I think we should err on the side of not promoting discrimination, or as a state body, secure it as an action and a belief that will make many Georgians be heavy of heart and fear that we're going to go back to the old ways of discrimination and unfairness. Thank you. I'll yield the will.
Chair recognizes Senator from the 46th, Majority Leader.
Thank you, Mr. President, ladies and gentlemen of the Senate. This issue of religious freedom has been with us for as long as we have had humanity. The elements of humanity are designated in the YMCA creed or code: mind, body, and spirit. Now, our spirituality is expressed through our religions, and there are many different religions. Religion's been with us always as well. It is an inalienable right, one that government cannot take away from us, that we are free to worship in accordance with our individually held beliefs. The senator from the 28th was speaking with me this morning and shared with me a quote by Justice Scalia in the Obergefell decision, as a matter of fact, in which he said, "It is of no special importance to me what the law says about marriage, because the Constitution places constraints on self-rule, constraints adopted by the people themselves when they ratified the Constitution and the amendments. Forbidden are laws that infringe on the right to keep and bear arms, to authorize unreasonable searches and seizures, to abridge the freedom of speech, or to prohibit the free exercise of religion. And there are many other rights that we reserve to ourselves in the Bill of Rights, in our Constitution, and said, government shall not pass laws that infringe upon these rights that we as a people agreed to reserve to us, free from infringement by the government." We put this right, freedom of religion, in the very First Amendment of our Bill of Rights. And you have heard the senator from the 54th very eloquently set forth the argument in the majority of that opinion that said, we're free to debate this and to have different opinions on this issue of marriage because the Constitution lets us. It stops our legislatures from infringing on how people choose to view that institution of marriage. Now, there are many faiths that profess that marriage is reserved as a sacrament between man and a woman and God. We leave out that part sometimes. This is not universally agreed upon by all faiths, or even by all denominations of the Christian faith. Some denominations permit same-sex marriage. Other churches limit this institution of marriage to one man and one woman. But our courts, our U.S. Supreme Court, has now clearly held that this institution of marriage, to the extent it is sanctioned by government, is available to same-sex couples or man and woman. Our Constitution also, though, protects the rights of all citizens to have their own belief system, their own religious beliefs as what is appropriate. I'd like to take a moment to applaud Representative Tanner and the Speaker for bringing this bill. My friend the Speaker has demonstrated inspired leadership on this issue. He has withstood withering criticism from many directions, at times from the faith community, at times from the civil rights community, at times even from the business community, and regrettably even at times from members of this body. The reason is that this issue generates such passion from people. It is a deeply held belief, generally for religious reasons, and it's healthy for us to have a passionate, spirited debate. Through it all, he has remained statesmanlike. He's refused to engage in personal attacks. So I thank you, Mr. Speaker. You will notice in this bill, the bill that passed the House with no dissenting votes, has not been altered by this body in any way. Every single word, every single punctuation mark is exactly the way you sent it to us. What we have done is simply expanded the protections that in this Protection Act protected only clergy, now extends to faith-based organizations and individuals. That's the meaning of a natural person. It's a human being. Individuals in this state, in this country, have religious freedoms. We now implement for the clergy that government won't interfere with their decisions on how to handle the sacrament of marriage. And also, this bill extends it to faith-based organizations. Whatever their view may be of what a lawful marriage is, it is clear it can be between same-sex couples or mixed-sex couples. Now, you have heard a lot of allegations raised in this debate, a lot of hyperbole. There are a lot of arguments that have been made here that are not accurate if you read the bill. Some of them actually are quite silly or ridiculous interpretations of the extent of this bill. There was a letter from clergy that was written long before this bill was introduced, referencing the Religious Freedom Bill from last year. And people forget the Senate version of that bill in its legislative findings at the very beginning makes it crystal clear that in the state of Georgia, we agree it is a compelling governmental interest to eradicate discrimination. This is not Indiana. We are in no way perpetuating discrimination against anybody. This bill is narrowly tailored. It only applies to adverse actions by the government, does not apply to actions by businesses. It protects only people and faith-based organizations, not businesses, unless they have put it in their articles of incorporation or their statement of principles that they are faith-based. Think about a church school, something like that it's part of that business's mission statement. It does not in any way protect or excuse government employees who fail or refuse to perform their official duties of government. It is not intended to allow anybody within government to discriminate against people based on their sexual orientation or what type of marriage they believe on their religious beliefs are appropriate. It protects all viewpoints on this issue. It's not intended only to protect people that believe in traditional Christian marriage. It also protects people who believe in same-sex marriage, which is now permitted by law. It truly protects all viewpoints from government interference on this deeply held conviction, whichever way you fall on that issue. It is absolutely live and let live. And it in no way interferes with the stream of commerce. So I'd like for everybody just to take a deep breath and settle down on this issue. It is not about discrimination against anybody in business or other relationships. It's to keep the government from taking away our inalienable right that we have embedded in the Constitution and the laws of this state to exercise your religion freely. Mr. President, I would ask that this body conclude this debate in the respectful manner we've handled it so far today, and I would ask your favorable consideration of this bill. Thank you. I yield the well.
Chair recognizes Senator from the 13, close the debate.
Thank you, Mr. President. Ladies and gentlemen, the media has reported that I compared the KKK to the Black Panthers. So let me make something very clear and encourage the media to report this as well. In no way does this legislation protect any criminal behavior under the guise of religious belief or expression. I in no way condone racist organizations, and I am proud of the constitutional protections that are in place today against racial discrimination in our state and in our nation. I do not condone criminal behavior of any organization such as the KKK, and this legislation in no way provides them any such protections. In fact, I've heard the words tolerance, acceptance, and understanding throughout the same-sex movement over the course of my life. HB 757 assures that all Georgians are tolerant of the belief that marriage is between two people, either a same-sex couple or the traditional view of marriage. The challenge of facing this issue is tolerance. Can those that believe in same-sex marriage tolerate those of us who hold that marriage is only reserved for a man and a woman? Millions of Georgians hold to the traditional definition of marriage. Just because the Supreme Court changed the definition in the law does not negate the definition in our hearts, our mind, our Bible, or our tradition. If tolerance of any alternative lifestyle is to be accepted, then shouldn't the beliefs of those who hold the traditional view of marriage also be accepted and tolerated? Live and let live is the motto of House Bill 757. Faith-based organizations should have the right to operate freely without fear of adverse actions from their government. One group's access to a right does not diminish the rights of another. Can Georgians who hold the same-sex marriage live with their ideology and let those who hold the traditional marriage live out their sincerely held beliefs? House Bill 757 ensures that there would be no discrimination for any Georgian concerning their belief in marriage. House Bill 757 in no way impedes, hinders, or otherwise interferes with a same-sex couple's right to obtain a marriage license or any other legal recognition or documentation in this state. It does not challenge the ruling of the Supreme Court that changed the definition of marriage. It simply protects the rights of those Georgians who continue to believe that marriage is between a man and a woman. House Bill 757 is important in ensuring that all Georgians are tolerant of each other's beliefs and that all Georgians can continue to pursue their dreams without discrimination. HB 757 protects pastors and churches as they minister according to their beliefs. Let's come together as a body in this Senate and in this state and show the rest of the nation that in Georgia we are tolerant, accepting, and understanding of everyone's rights concerning marriage. Ladies and gentlemen, I ask for your favorable consideration for House Bill 757. Mr. President, I yield the well.
The question is on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree on the report of committee which fail pass the bill? Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Question is on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. All members voted. All members voted. On the passage of the bill, the yeas are 38 and the nays are 14. And this bill, Alabama City Records constitutional majority, is therefore adopted. Yeah. We've got just a little bit of other quick business to take care of. Chair recognizes Senator from the 7th.
Mr. President, I ask unanimous consent to suspend the rules and read two bills for the first time so they may be assigned to committee. Bills are Senate Bill 404 and House Bill 751.
Secretary will read.
Senate Bill 404 by Senator Harper the 7th and others, a bill to be entitled an act to amend Chapter 2 of Title 35 of the OCGA relating to the Department of Public Safety so as to revise provisions for the off-duty use of motor vehicles by certain law enforcement officers of the department relative to approved off-duty employment to provide for related matters to appeal convicting laws and for other purposes.
Is there objection? Chair recognizes Senator from the 41st.
Mr. President, would it be appropriate for him to just briefly tell us why he wants the rules waived and moving them along that fast?
We're just first reading and assigning the bill. We did that for the Senator from the 26th.
No objection. No objection, Mr. President.
And the other one is the budget, too. Is there objection? Without objection, we'll send, this goes to public safety. Who's moving on this one?
He's already
He moved, all right. Secretary will read.
House Bill 751 by Representatives Rawson of the 7th and others, a bill to be entitled an act to make and provide appropriations for state fiscal year beginning July 1st, 2016 and ending June 30, 2017 to make and provide such appropriations for the operation of the state government and for other purposes. Mr. President, that completes the order.
Is there objection? Without objection, we will place the appropriations, it in appropriations. Appropriations bill and appropriations. Okay, I think that's all of the business. Chair recognizes Senator in the 46th.
Mr. President, I move the Senate stand adjourned pursuant to House Resolution 1114 till 10 o'clock a.m. on Monday, February 22nd.
Read the announcements.
Agriculture and Consumer Affairs has been canceled. Insurance and Labor has been canceled. Regulated Industries and Utilities has been canceled. Public Safety General Welfare Subcommittee has been canceled. Science and Technology has been canceled. Veterans, Military, and Homeland Security has also been canceled. Finance has been canceled. Health and Human Services will be held at 4:30 and 450 Capitol. Education and Youth will also be held at 4:30 and 307 CLOB, and Public Safety will be held at 4:30 and 125 Capitol. Mr. President, that completes the announcements.
Public safety has been canceled. Public safety has been canceled today. Public safety has been canceled. There's no safety for the public, I guess. On Monday. Have to go a long weekend. That ain't a good thing. All right, any other announcements? The majority leaders move. We stand adjourned until 10 a.m. Monday, February the 22nd, 2016. All those in favor will say aye. All those opposed, no. Ayes clearly have it. We stand adjourned.